Hey guys, Ramic here, your friendly car accident lawyer here in the St. Louis area, and today we're going to talk a little bit about all the phases that go into a car accident lawsuit. And in this video I'm going to just generally talk about all of them, and then in subsequent videos I'll try to go a little bit deeper into each one of those sections. So every time I sit down with my client, my stance is count on being with me for the next 6 months to a year if we are able to resolve this as a claim, and if not, then we're going to litigate, and then count on being with me between a year or two. And so the very first stage of a lawsuit, and we try to do this as much as possible, and we have to keep in mind that the vast majority of personal injury car accident cases are resolved before we have to file a lawsuit. So about 90% plus are resolved before we ever have to file a lawsuit. So the first phase is the pre-suit demand, and if we're able to resolve that case there and then without having to file a lawsuit, we do it. Obviously keeping in mind the value of the case, what the client wants, and so on. The next step, if we don't get a resolution before filing a lawsuit, is obviously to file that personal injury lawsuit. And that involves paperwork submitted to the court and so on. The next step is the issuance of summons, which means that either the sheriff goes to the defendant and hands him the paperwork, or we find a special process server to do that on our behalf. And that gives notice to the defendant driver as well as their insurance company the lawsuit has been started. The next step is going to be the answer. So the insurance company or the lawyer for the defendant enters on their behalf, and they answer our complaint, basically admitting or denying all the allegations that we've put into our petition. Next step is the written discovery. So basically we exchange with the defendant questions. We send a set to the defendant, and then the defendant sends one set to our client, and we fill those out with our client. Next step would be the deposition of parties. So we sit down with the defendant, and then we get to ask him or her any and all questions that were not answered through discovery, or where we want to go a little bit deeper. And the defendant and their lawyers have got the same right to sit down with our client and ask any and all questions. Well, I say any and all questions, obviously they can't just go digging around. There are some parameters that they have to abide by. So if we can reach an agreement after that, that's fine. If not, then we've got to depose non-expert witnesses. So somebody that saw what happened, heard what happened, is not going to give their opinion. So it's just going to be, what, how, why. Next step is going to be then, and this is very close to trial because the expert depositions are very, very expensive. If we have to depose an orthopedic specialist, those can run in the thousands of dollars, and we try to hold off on that until very close to trial. And if we are unable to settle after that, obviously then we go to trial. Jury of our peers is going to sit there, listen to our arguments, and then make that decision. Hopefully this helps, and if you have any other questions, call me at 314-352-6800. Thank you very much, and you have a good day.